9 justices, 0 dissents, an emergency ruling that landed like a detonation in the middle of the American election system. And right now, in July 2026, the way votes are counted, the way congressional districts are drawn, the way winners are certified, and the way your voice translates into actual political power may have just been permanently altered by 9 people in black robes who agreed on something so completely, so unanimously, that not a single one of them, not the liberals, not the conservatives, not the swing votes, broke from the majority. Let that land for a second. We are living through a period in American jurisprudence where 9 justices agreeing on anything is treated as a minor miracle, where the court splits 5-4 on questions about the color of the sky, where dissents have become the default mode of communication from one judicial faction to another, and in the middle of that fractured, partisan, deeply divided institution, something happened that produced a unanimous verdict. Something happened that 9 people with radically different judicial philosophies, radically different views about the role of federal power, radically different approaches to constitutional interpretation, looked at and said with one voice, no, this cannot stand, this will not stand, not on our watch. The Supreme Court of the United States just issued an emergency ruling on America's election infrastructure. The maps that determine who represents you in Congress, the systems that determine how your vote is counted, the standards that determine how your voice translates into actual political representation. All of it sits inside a legal framework that the court just fundamentally reconfigured. State officials are scrambling right now. Election administrators are in emergency sessions right now. Legal teams across the country are pulling all-nighters right now. And most Americans have no idea any of it is happening because the mainstream media is drowning it under partisan theater and political noise designed to keep you distracted from the things that actually control your life. That ends here. If you want the unfiltered truth about what just happened to American elections, not the sanitized version, not the version filtered through party loyalty, not the version engineered to make you feel comfortable and compliant, you are in the right place. Subscribe to this channel. Hit that notification bell, share this video with someone who still believes their vote is secure, their election is protected, and that the courts are just quietly doing procedurally boring things that don't affect them. Because what I am about to walk you through is the most consequential legal development in American election law in a generation, and you deserve to understand every single word of it. To understand why this ruling hit the way it hit, to understand why 9 justices with nothing else in common found unanimous ground here, you have to understand the legal architecture that was supposed to govern election administration in this country, the framework of rules, standards, and binding precedents that were supposed to prevent federal courts from becoming unelected, unaccountable supervisors of American democracy. You have to go back to the doctrinal foundation, the body of law that the Supreme Court had built, piece by piece, ruling by ruling, over decades, establishing precisely how federal courts are allowed to intervene in state election systems. That framework was not vague. It was not ambiguous. It was not open to creative interpretation by district court judges who happened to prefer a different outcome. It was a binding, explicit, ironclad set of standards telling every federal court in America exactly where the line sits between legitimate judicial oversight and unconstitutional judicial overreach. And that framework rested on a principle so fundamental, so deeply embedded in the structure of American constitutional democracy, that it predates every living justice on the current court. The principle is this: elections belong to the states, not as a matter of political preference, not as a partisan talking point, as a matter of constitutional architecture. The founders built a system in which the states, not the federal government, and certainly not federal judges, retain primary authority over how their elections are conducted, how their votes are counted, how their congressional maps are drawn, and how their democratic processes function. Federal courts exist within that system as a check against specific, concrete, proven violations of federal law. They exist to intervene when states cross clear constitutional lines. They do not exist to substitute federal judicial preferences for state democratic choices. They do not exist to redesign election systems or redraw congressional districts because a federal judge believes a different design would produce a better outcome. They do not exist to become permanent supervisors of state electoral machinery, embedding their institutional preferences so deeply into the system that correcting them becomes politically and practically impossible. That was the law. That was the framework. And then came the pattern of lower court conduct that brought the Supreme Court to a unanimous emergency response, because what happened in the courts below was not a borderline case. It was not a close call. It was not a situation where reasonable judicial minds could differ. What happened below was a systematic, documented, identifiable pattern of federal judicial overreach into state election systems that 9 Supreme Court justices looked at and unanimously agreed had to be stopped right now, before another election passed, before the damage became permanent. What the lower federal courts did, the pattern of conduct that triggered this unanimous emergency intervention, has to be understood in specific, concrete terms. because the details reveal something far more disturbing than a single judicial error. They reveal a theory of federal judicial power over state elections that, if left uncorrected, would have fundamentally changed what American democracy actually is. The lower court in this case received explicit instructions from the Supreme Court to apply the law faithfully. It received those instructions, and then it issued a ruling that 9 justices unanimously agreed failed to apply them. 9 justices, 0 dissents. That is the institution saying this was not a close call. This was not a difficult interpretive question where reasonable courts could differ. This was a court that received binding guidance from the highest judicial authority in the country and produced a ruling that guidance clearly did not authorize. When that lower court blocked a state's legislatively drawn congressional map, replacing it with a map drawn by a court-appointed special master, an official not elected by a single voter, who answers to the court and the court alone, it crossed a line the Supreme Court had drawn clearly and repeatedly. The map created by elected state representatives, people accountable to the voters of that state, people who can be removed from office if their decisions fail their constituents, was substituted by a bureaucrat's map, and the lower court's justification for this substitution, stripped of its legal language, amounted to little more than administrative convenience. The court-drawn map was already in use. Changing it would be disruptive, and therefore we are keeping it regardless of whether our legal basis for imposing it was ever sound. That is not judicial restraint. That is entrenchment. It is a court protecting its own prior intervention from correction on grounds that have nothing to do with the legal merits. When you cut through all the procedural language, the lower court was really saying that the act of judicial imposition, repeated often enough and embedded deeply enough in the administrative system, eventually becomes self-justifying. It becomes too embedded to correct. That is a principle that cannot stand in a constitutional system where courts are supposed to operate within defined legal boundaries, not build institutional momentum that insulates their decisions from review. The Supreme Court recognized it as exactly that, and tore it apart with unanimous force. The first error the Supreme Court identified goes to the absolute foundation of how federal courts must approach state electoral systems. And it is the error with the most immediate, most far-reaching consequences for every federal election case pending right now across every circuit in this country. It is the presumption of good faith. The principle is direct. When a state legislature acts, when it draws maps, passes laws, or makes governing decisions, federal courts are constitutionally required to begin from the presumption that those officials are acting in good faith, not blind faith, not immunity from legal challenge, presumption. The default starting position, before specific concrete evidence of specific concrete violations has been introduced, is that elected state officials administering elections and drawing legislative maps are doing so for legitimate reasons rather than illegitimate ones. This presumption is not a courtesy, it is not a procedural nicety extended to powerful institutions, it is constitutional architecture. State legislatures are democratically accountable. If they make a bad map, they can be voted out. If they make a discriminatory map, they can be challenged at the ballot box. Federal judges, conversely, are not accountable to you. When a federal court overrides a state legislature's judgment, it is substituting the decisions of appointed elites for the decisions of the voters. The presumption of good faith is the guardrail designed to ensure that this substitution only happens when there is ironclad legal justification, not when a judge simply prefers a different outcome or finds a different procedure to be administratively comfortable. When a federal court erases this presumption, when it begins its analysis from the assumption that state officials are acting in bad faith, that their procedures are designed to suppress votes, that their maps are drawn with discriminatory intent, that their entire electoral apparatus requires federal supervision to function legitimately, it has substituted its institutional judgment for the democratic choices of millions of voters who elected those state officials to do exactly what they are doing. It has placed unelected federal judges above elected state officials in a hierarchy that the Constitution does not authorize. The lower courts did not just fail to apply this presumption, they inverted it. Systematically, repeatedly, in ways that the Supreme Court majority found fundamentally incompatible with the American legal system. Here is specifically what they did. State election officials and state legislatures, as they are constitutionally entitled to do, exercised their legal rights to challenge federal court orders they believed were unlawful. They appealed adverse rulings. They filed motions. They advocated vigorously for their legal position through every mechanism the appellate system provides. This is standard litigation behavior. It is protected by the First Amendment's right to petition the government. It is the kind of vigorous legal advocacy that occurs in federal courthouses every single day. And the lower courts took that completely normal, constitutionally protected legal advocacy and used it as evidence of discriminatory intent in administering their elections and drawing their maps. Read that carefully. Let that logic fully register. If you challenge a federal court order through proper legal channels, your challenge becomes evidence that your election administration is corrupt. If you appeal a ruling you believe is incorrect, your appeal becomes proof of illegitimate intent. If you fight for your legal position through every mechanism the system provides, your fight becomes a weapon turned against you. Under this framework, a state that simply accepts every adverse federal ruling without resistance is presumed to administer its elections in good faith. A state that dares to contest those rulings through the exact process the appellate system exists to provide is presumed to administer them with corrupt or discriminatory intent. The practical consequence is a binary choice: surrender to federal judicial supervision without legal contest, or have your legal advocacy used as evidence against you. That is not a choice the Constitution offers. That is a trap the lower courts constructed, and the Supreme Court dismantled it with language so unambiguous that no clerk in the federal judiciary could misread it. The majority was unambiguous. Disagreeing with a court order through the proper appellate process is not evidence of discriminatory purpose. It is the system functioning exactly as it was designed to function. Using a party's legal advocacy against them in this way does not just get the law wrong. It threatens the ability of any litigant, any state, any election official to defend their legal position without that defense being weaponized against them. By correcting this, the Supreme Court just told every federal court in America the presumption of good faith is non-negotiable. No court gets to erase it simply because a state is fighting for its position. If this analysis is reaching you in ways that the mainstream coverage has not, if you are understanding for the first time what is actually happening inside the legal system that governs your elections and your congressional representation, drop a comment below right now. Tell me what question this raises for you. I read every single comment. The best ones become future videos. Subscribe if you have not already. Share this with someone who votes in every election but has never heard the phrase presumption of legislative good faith, because those words just became the legal foundation on which their next election rests. The second error the Supreme Court identified goes to the evidentiary standards federal courts must apply when challengers claim that state election procedures or legislative maps violate federal law. And this error, in the specific way the lower courts committed it, had been quietly spreading through the federal judiciary for years, accepted, normalized, treated as standard practice, until 9 justices looked at it all at once and said, no, this is not the standard. This has never been the standard, and every court that has been applying it this way has been getting the law wrong. The framework the Supreme Court had established demanded that challengers who claim a state election procedure or legislative map violates federal law must demonstrate that alternative compliant procedures or maps exist that perform equally well across every relevant dimension, not the dimensions most favorable to the challenger's argument, not the metrics that happen to tell the story the challenger once told. Every dimension, full performance across the complete range of relevant factors. In redistricting cases, challengers had been submitting alternative maps to show the court that a different, supposedly more fair map is possible. But courts had been permitting what can only be called selective compliance. They would present a map that performed well on one specific racial metric, like the percentage of minority voters in a given district, while completely ignoring every other principle that governs legitimate map drawing: geographic coherence, keeping established communities intact, protecting municipal boundaries, and the administrative realities of running elections at scale across rural, suburban, and urban communities that do not share the same infrastructure, the same resources, or the same logistical capacity. A proposed alternative that performs better on one measure while ignoring administrative feasibility, ignoring the operational realities of running elections at scale, ignoring the costs imposed on local jurisdictions, ignoring the downstream effects on voter accessibility across different communities. That proposed alternative is not evidence that the state's procedure or map is deficient. It is evidence that the challenger has engineered a procedure optimized for their legal theory, not for the actual conduct of actual elections serving actual voters. The lower courts had been allowing challengers to prevail by emphasizing their preferred metrics, while the full dimensional analysis the Supreme Court's framework required simply did not happen. Courts looked at the numbers challengers highlighted, found those numbers persuasive, issued orders requiring states to change their procedures and redraw their maps, and the complete, rigorous, all-dimensions analysis that would have revealed whether those alternative procedures and maps actually protected voters across every relevant concern, not just the single concern the challenger had strategically foregrounded, was treated as optional, as something that could be addressed later, as a detail rather than the requirement it had always been. The Supreme Court's answer was definitive. Partial compliance with the evidentiary standard is not compliance. If you are going to challenge a state's election procedure or legislative map, Your alternative cannot just be a race-optimized piece of paper. It has to be a functional system that honors the legitimate principles that states actually use when making these decisions. If your alternative map is geographically incoherent, if it fragments established communities, or if it ignores every redistricting principle a state normally applies while optimizing for a single legal metric, it fails. You do not get to ignore the state's legitimate interests just because the challenger found a way to optimize for one specific goal while the full picture goes unexamined. The practical consequences of this recalibration cannot be overstated. Every redistricting case currently pending in federal courts across this country, every challenge to a state election procedure active right now in multiple circuits, all of it now sits against a fundamentally changed legal backdrop. Every judge who has been allowing challenges to succeed on selective metric analysis while the full performance review goes undone has just been told by 9 justices that they have been applying the law incorrectly. That message was delivered in writing, in a unanimous opinion, and it will outlast every news cycle. The third error, the one that carries the deepest constitutional weight, the one that the majority surrounded with language that went far beyond the narrow procedural question immediately before the court, reaching into the fundamental architecture of American democracy and the limits of federal judicial authority within it. The Purcell Doctrine, named after the 2006 Supreme Court case Purcell v. Gonzalez. If you follow election law, you know this name. If you do not, you need to, because it is one of the most important principles governing when federal courts can and cannot intervene in ongoing elections. And what just happened to it, the way the lower courts had been applying it, and the way the Supreme Court unanimously rejected that application, changes the legal landscape of federal court intervention in elections in ways that will be felt for decades. The Purcell Doctrine holds that federal courts should not impose changes on election procedures, systems, maps, or rules close to an election. The reasoning is simultaneously practical and profoundly democratic. Last-minute judicial changes to how elections are conducted create confusion for voters who organize their participation around existing procedures. They create chaos for administrators who built their operational systems around the rules that were in place. They damage public confidence in democratic processes by making the rules of the game appear unstable and subject to change at the discretion of unelected judges at the exact moment voters are trying to make choices about their representation. The lower courts developed an answer to Purcell that sounded, on first hearing, superficially reasonable. Their position was that the changes they had imposed on state election systems had already been implemented. Administrators were already operating under the judicially modified procedures. Voters were already familiar with the court-drawn maps. Reversing those changes now, returning to the procedures the state legislature had actually enacted, restoring the maps the state legislature had actually drawn, would itself cause the disruption Purcell is designed to prevent. Under this theory, the lower courts were not violating Purcell. They were applying it. They were protecting elections from disruption by keeping their own prior disruption in place. Think about that logic. The lower court had imposed its own map and its own procedures over the legislature's choices. Now, when faced with the fact that its impositions rested on legally unsound foundations, the court said, "We have already disrupted the system once, so you have to let our disruption stand, because changing it back would be too disruptive." Examine that argument carefully. The Purcell Doctrine exists to protect elections from last-minute judicial interference, and the lower courts were arguing that this doctrine, designed to keep federal courts from disrupting elections, should protect the disruption federal courts had already imposed from being corrected. That is not Purcell. That is Purcell dismantled and reassembled into a shield for judicial overreach. That is the doctrine designed to constrain federal court intervention being repurposed as a mechanism to make prior federal court interventions permanent. The Supreme Court saw through it immediately. A court-imposed change that lacks adequate legal foundation is itself a Purcell violation, and maintaining that change is not Purcell compliance. It is Purcell defiance dressed up in Purcell language. And then the majority went further, significantly further. The court wrote about state sovereignty over electoral processes in constitutional terms that transcended the immediate question before it. Sovereign states have the authority, the constitutional right, to conduct their own elections and draw their own legislative maps according to their own democratically enacted procedures. A federal court's institutional preference for the procedures it imposed does not override that sovereignty. A federal court's concern about administrative disruption does not override that sovereignty. The comfort level of federal judges with the systems they built does not outweigh the democratic authority of state legislatures to govern their own electoral processes. That constitutional framing will be cited in redistricting cases, in election administration cases, in voter ID cases, and certification dispute cases for the next 20 years. It is the court writing into permanent legal record that there is something categorically, constitutionally wrong, not just procedurally incorrect, not just legally mistaken, but fundamentally incompatible with American constitutional democracy, about federal courts constructing permanent supervisory roles over state election systems by embedding their preferred procedures so deeply that removing them becomes practically impossible. There were justices who disagreed, and their arguments deserve to be taken seriously as the genuine legal positions they are, because the tensions they identify are real. The dissenters argued that restoring the original state procedures and legislative maps on an emergency basis created exactly the administrative disruption that Purcell is supposed to prevent. They argued that states had, through their pattern of legal resistance to prior court orders, contributed to manufacturing the urgency they were now invoking to justify emergency relief. They argued that the election infrastructure built around the court-modified procedures could not be cleanly reorganized around the original legislative procedures without costs that would fall directly on voters. These are not frivolous arguments. These are serious legal positions from serious legal minds engaging seriously with genuine constitutional tensions. Reasonable legal minds can disagree about how these principles apply in a situation where correcting a prior legal error itself introduces new disruption into an already running system, but they lost. All of them, 9-0 on the core holding. The stay was granted. The constitutionally enacted state procedures were restored. The legislative maps were reinstated. And the majority's reasoning about the presumption of good faith, about evidentiary standards for challengers, about the Purcell Doctrine, about state sovereignty, is now the binding legal framework that every federal court in America must apply to the election cases on their dockets right now. Here's what you need to understand about the full national scale of what just happened. Supreme Court emergency rulings on election cases do not function only as resolutions of the specific disputes immediately before the court. They function as direct, formal, documented institutional communication from the Supreme Court to every federal judge in America about what the court expects, what it will not tolerate, and what will happen when those expectations are violated. This is a clear institutional message to the entire federal judiciary. The era of selective compliance is over. Federal courts that receive binding Supreme Court precedent on election law standards must apply that precedent fully, completely, faithfully, not selectively, not in citation only while reaching conclusions the framework does not actually support, not through creative reinterpretation that allows a court to claim compliance while producing exactly the outcome the framework was designed to prevent. Courts that do otherwise can expect the Supreme Court to intervene at speed, to overrule them publicly, and to identify their specific errors by name in written opinions that become permanent parts of the legal record. That is an institutional deterrent of extraordinary force, and it was delivered with maximum clarity by 9 justices who found no grounds for disagreement. Right now, in the summer of 2026, the implications of this ruling are radiating outward through the federal judicial system in real time. There are federal court orders currently imposing requirements on state election officials and overriding legislatively drawn congressional maps that were issued under the legal frameworks the Supreme Court just rejected. There are district court judges who have to look at those orders right now and ask whether they can survive review by a court that just unanimously rejected the reasoning that produced them. There are state governments that have been operating under the assumption that federal courts would continue expanding their supervisory role over election systems, and that assumption just received a unanimous, emergency, documented correction from the highest court in the country. For state election officials who have been operating under the cloud of federal judicial supervision, who have been modifying their procedures and their maps not because their state legislatures required it, but because federal court orders demanded it, this ruling is a restoration of the authority that the constitutional design says belongs to them. The presumption of good faith has been placed back on its constitutional foundation. The standard that challengers must meet to override legislatively enacted election procedures and congressional maps has been clarified and strengthened. The sovereignty of states over their own democratic processes has been reaffirmed in language that will anchor legal arguments for a generation. For voters who believe that the rules governing their elections and the maps determining their congressional representation should be set by the people they voted for rather than by unelected federal judges pursuing their own theories of electoral optimization, this ruling moves the legal landscape back toward a framework where that belief is supported by constitutional doctrine rather than intention with it. The emergency stay is not the end of this story. It is the most dramatic chapter so far. But it is not the final chapter. A petition for certiorari is coming, a request for the Supreme Court to take this case on its full merits, not just the emergency stay question, but the complete underlying constitutional questions about the scope of federal judicial authority over state election systems. That petition will be filed against the backdrop of a majority opinion that has already signaled how the court is likely to approach those questions. Because when the Supreme Court writes, in an emergency stay opinion, that the parties seeking relief have demonstrated a likelihood of success on the merits of their constitutional claims, that is not boilerplate language. That is the court signaling in the formal language of Supreme Court jurisprudence the direction of its analysis before full briefing even begins. The next 60 days will determine whether that petition lands on a timeline that allows the court to act before another election cycle passes. They will determine whether lower courts use the stay opinion as authorization to begin unwinding the supervisory infrastructure built under the rejected frameworks. They will determine whether the constitutional questions raised here, about the scope of federal judicial power over state elections, about the relationship between federal court oversight and state democratic authority, about the standards governing when federal intervention in state electoral systems is constitutionally justified, receive the full Supreme Court treatment they now clearly demand. 9 justices. 0 dissents. On a ruling about the fundamental architecture of federal judicial power over American elections. The court has drawn a line in language that cannot be misread and will not be forgotten. It has told every federal court in America that the presumption of good faith for state election officials and state legislatures is not negotiable, not optional, not something courts can erase because they find the idea of state electoral authority inconvenient. It has clarified that the evidentiary standards challengers must meet to override state election procedures, and legislative maps require full dimensional analysis across every relevant factor. Not selective metric emphasis, not alternatives that perform better on one measure while performing worse or untested on everything else. It has reclaimed the Purcell doctrine from a version of itself that had been bent into a protection for prior judicial overreach and restored it to its original constitutional function, a constraint on federal courts, not a mechanism for making federal court interventions permanent. And it has written about state sovereignty over electoral processes in terms that place that sovereignty on the highest constitutional ground, above federal judicial preference, above administrative convenience, above the institutional comfort of courts that have grown accustomed to supervising systems they were never constitutionally authorized to build. The legal landscape of American elections just shifted. The framework governing how federal courts can intervene in your state's election administration, your state's certification procedures, your congressional district boundaries, your vote counting systems, all of it just changed in ways that most people will not understand until the next election, when the consequences become visible in the actual conduct of actual elections affecting actual lives. That is the story. That is the ruling. That is why it matters to every voter in every state, regardless of party, regardless of which candidates they support, regardless of which issues they care about, because the question this ruling answers is prior to all of those questions. It is the question of who gets to decide how your democracy works, your elected representatives or unelected federal judges who have decided that supervision is its own justification. The Supreme Court just gave that question a unanimous answer. The moment the next development breaks, the certiorari petition, the court's response, the implications for cases in other circuits, the first lower court rulings issued in the wake of this stay opinion, I will be here with the complete breakdown before the news cycle has moved on. Subscribe. Hit that notification bell. Leave a comment telling me what question this ruling raises for you. I read every single one, and the best questions become future videos. Share this with someone who votes in every election but has never thought about whether the rules of that election were set by people they voted for or people they did not. Because that question has an answer now, a unanimous one, and you deserve to know what it is. This channel exists because the truth does not promote itself. Subscribe. Stay close. The story is not over.